Hi, and welcome to another class of Business Law and Ethics. Today we're going to do Property Law, Chapter 7, Part 1. What I'd like you guys to do as much as possible, there's a lot of information here that has to be shared, and certainly with all this information sometimes it does get to be quite a few things to get to know of, and sometimes you might not or you might miss out on a couple of definitions, or not sure about if the definitions in the PDFs are correct, or correct maybe, but if they are up to date or if they are clear. So I would say clear more than anything else. So as you can see, or you will see, I have updated the PowerPoint to make it a little bit more clear, and also what I did was I added some information about Quebec, which by the way will be in the quiz later on. Okay, so just make sure that when we do the quiz, there will be questions based upon everything that you see in the PDF and in the PowerPoint. Okay, so let's get going. So learning objectives on this chapter has got to do with property rights and also its protections here in Canada. Distinguish also ownership from possession, and we will look at real and personal property, chattel or goods. So let's get right into it. So if we look at real and personal property, if you look at real property, this refers to land and things that are permanently attached to the land, like buildings, certainly. So anything that is permanently attached is considered to, or is called real property. If we look at personal property, this is movable. And it comes in two categories: chattel or goods, or choses in action. Yes, that is correct. Choses in action. So if you look at chattel or goods, this is movable and tangible. So this can be measured and can be weighed. An example would be a car. Okay. So if you had a shed in your backyard, this would not be a chattel. It has to be movable. Choses in action, it's intangible rights. This is the right to sue. So here, if you have shares or certificates, these are choses in action. So this is still considered to be a personal property, but it's not tangible like a car. So let's take a look at fixtures and chattels. A fixture is an item that is attached to the land, right? As we saw, fixture or real property. And a chattel is an item, even if attached to land, it is movable or removable, shall not form part of the land. So if you look at real property, there's three types. There's ownership, rights to possession, and also estates in land. Okay, so the interests in land, I will not read through all of this. Again, I really want you guys to pay attention to, you have a lot of time on your hands to study and to be prepared for the quiz and the questions. So you should have less time in class of lecturing or questions for sure. Now, as I said that though, I certainly don't mind if you do have questions about certain things. I would be more than happy to answer them as best as I can. But you have all the time in the world now, and I'm hoping you're all staying safe, but you do have the time to research and take a look at what's coming up. So this is called flipping, and if you have the chance to flip the class and know more about what's going to take place in the class beforehand, this is to your advantage and certainly to your grades. All right, so interests in land. Only the portion that the owner can permanently use or occupy is not considered to be part of the property, right? So if you have certain zoning regulations, may limit the type or size of building that can be erected, as well as the activity that can take place on the land, right? So areas above and below the surface are excluded. Subsurface rights usually belong to the Crown. So in other words, whatever is underground is not yours. Property owners entitled to compensation for surface disturbance. If there is any disturbance, if they have to dig, whatever, for whatever reason, will be compensated, right? So a landowner has, let's say, no actionable complaint when an airplane flies over the property, But power lines or an overhanging building that intrudes into is supported by some legal right, such as easement, which we'll get into, would give the right to a right to sue for trespass. Okay, so we'll get into that. Estates in land, you have a fee simple, a life estate, and you have leasehold estates. So if you look at all three of them one by one, a fee simple is the ownership, the greatest interest a person can have in an estate. It can be inherited. It can be also expropriated under certain circumstances in case of they need the land to do something. Certainly what's going on in Canada today and around the world, where the laws and rules and regulations are changing almost daily, certainly there's a lot of things that could be done in this case, and they would do it even exponentially. So this could be something that you have to understand, that when a country like ours is, or any country is in a certain situation of drastic measures, certainly expropriation is something that will happen very, very quickly. Life estate, here the holder has exclusive possession of an estate. Upon his death, the property reverts to the original owner. It cannot be inherited. So life estates are not particularly common here in Canada. So you'll have them more in Britain or in the United States. Leasehold estates, known as leases, certainly, so limited to a specific period, after which the property reverts to the landowner, maybe short-term or long-term, can take the form of periodic tenancy until terminated by notice. So if you look at also lesser interests in land, easement. So easement gives a person or a government the right to use, or a municipality, the right to use a portion of another's land, usually for a particular purpose. Now, what does that mean? We'll get that in a couple of seconds. There's also right of way, gives a right to cross another's land, usually to get to their own property. So if the only way to get to somebody's property is through somebody else's, then they have the right to do that. This is called right of way. It does not give that person the right to stop, park his car, or build some permanent structure on that property. All it gives you the right is to pass. So here's an example of easement. There's always a piece of land in front of, when you buy a home, at the beginning, at the front of the home, which is really not yours, and you're not even paid for, you're not paying taxes on that either. So if there is a water main there, like most homes, or if there is snow removal that could be damaging, or there's a curb and all of that, if you see there's a curb here, certainly that is the city's property. So if there is a gas line that comes under, or in this case is a water main that comes under, this is not your property. This is a property. It is still considered to be your property, but it's an easement area where someone can come in and do specific changes to it. Here in Quebec, as I mentioned earlier, I'll refer to certain things in Quebec. There's websites. I have attached a website. You can take a look at it to see what the right of way here in Quebec. So very quickly, if you own a property that does not have access to a public road, or that has inadequate or impassable access, you may ask a neighbor to grant you the right of way in return for compensation. If your neighbor agrees to your request, you must both sign a contract setting out details of the right of way. Okay? If your neighbor refuses to grant you a right of way, you may ask the Superior Court to issue a court order requiring him or her to do so. So in this case, most cases, if you do acquire a piece of land where you have no access but to go through, they certainly have to give it to you. Lesser interests in land. So if you look at licenses, permission given to a person to use another land, so allowing the public to shop in a mall or a patron to rent a hotel room. So this is called licenses. Easement acquired by prescription. In some provinces, a right to land can be acquired by use. To avoid it from arising, the landowner must periodically exercise some control, like blocking access from time to time. So these are all rules that you won't see very often. This is just more, again, for your information of definitions. Less interest in land again. Adverse possession. This occurs when someone has had possession of a land for a long time with the knowledge and toleration of the owner. So the number of years varies, and several Canadian jurisdictions, specifically those that land title system, have abolished both. So adverse possession means you don't actually own the land, but you've been living on the land, right? So restrictive covenant, this is restrictions that can be imposed, like type of building it can be put on the land, or how the property may be used, such as for residential, commercial, or light industry. So restrictions apply not only to the purchaser, but also to any subsequent purchasers of that land. And also, in this restrictive covenant plays a big part here in Quebec with Airbnb, where now you cannot, if you certain parts of Montreal, you cannot lease your apartment to Airbnb. So this would fall under restrictive covenant. So tenancy, which is leasing, in common and joint tenancy. So both are ways to own property together. So tenancy in common is undivided interest. So if one dies, that person's heir inherits his or her interest. Joint tenancy, if one dies, the other one will be left with the whole property. So let's say husband and wife own property jointly, one dies, the other continues to own all the property. So this is if you have both names on the property when you bought it, certainly it just automatically goes to the other person. This is joint tenancy. Now, tenancy in common, though, that is up to you to decide who gets your share. So here, joint tenancy, there's no inheritance, no estate taxes, and it just goes to the other person. Look at condominiums, which is dotted our landscape here in Quebec like it has in other provinces and around the world. So this is really a building that is shared, and the condominium association is incorporated and functions in a way like a company or a society. So you have to pay fees and stuff like that. So regular meetings where each member owning or using has a vote. Bylaws are passed that outline the rights and duties of members, such as in case if you don't want to have pets, children, smoking is a big thing. Airbnb, again, plays a big part in condominiums now, where the members have voted down Airbnb, where you cannot have the Airbnb in certain condominiums. In some others, you can. It all depends how you voted in favor or against. And then there's also cooperatives. This is not as common as other ones, so members are also cooperating in the administration of the project. Basically what this means is that if you have, let's say, a duplex or a triplex, you own 1/3 of that building, right? So the entire property might be owned by one corporation, but it certainly has separate entities. So it has disadvantages like the condominiums, where there is certain laws or bylaws and there's certain fees that you have to pay. So cooperative basically means you own it. There is no meetings for you to have, and certainly this is it's your property. Next one is transfer and registration of an interest in land. So the first stage, creation of an agreement of purchase and sale between the vendor and the purchaser. All the terms and special conditions must be properly set out in the agreement of purchase and land. In Canada, we do have two systems, and both require registration. So the western provinces, the territories, New Brunswick, Nova Scotia, also Ontario, have taken the registry system one step further and adopted a land title system where the title to real property is guaranteed. In this system, once registration has taken place, in a central registry is created and registered as binding to all parties. So the key to understanding this system is that the certificate of title determines the interests of the parties listed on it to the land specified. With purchasing land or purchasing property, in most cases you will have mortgages. So a homeowner or a mortgager transfers title to the property to the mortgagee as security for the loan. So a mortgage agreement is calculated on repayment of a debt over a long period of times. Usually it's 25 or 30 years. However, the mortgage agreement usually has a fixed duration of a much shorter time of 5 years. So you can have an agreement and it's very short, but the actual is calculated on payments of 25 to 30 years. So this allows the parties to adjust the interest rate and other terms. So in 5 years, if the interest rates have changed, they will change. So if they're going up or going down, you're going to have to reach a different agreement. Also, as it says there, if the value of the property fluctuates, certainly the mortgage rates will fluctuate and the value of the house or the property will fluctuate or change. Landlord-tenant relationship. This is a big issue across Canada, and each province, this is run by the provinces and run by, like I said, by the provinces, and they all have different rules and regulations. Us, when I say Quebec compared to Ontario, it's almost two different worlds when it comes to landlord-tenant relationships. But mind you, it's changing quite a bit here in Quebec because of the value of a property has really exploded, and so the government has to stipulate even stiffer rules and regulations for landlords or landowners, owners, I should say, to make sure they follow rules and regulations. Again, you might say that tenants are the ones that are always paying the price because everything goes up. But you have to understand by landowners is that there's always going to be construction or there's always going to be repairs. In a lot of cases, a lot of tenants are not exactly all saints, as if I may use that word, and there's a lot of damages that they cause that they might not be liable, but unfortunately the landlord has to pay. This is where insurance comes into play. Excuse me. So for a specific or determinable period, usually ending on a specified day or the end of a specified period. Again, like I said, here we have certain rules and regulations, and other provinces also, and it's not the same thing. So it also may take form of a periodic tenancy. Special period is automatically renewed if you don't do anything about it. If you don't increase, you don't send a letter of increase. There's a whole bunch of things. So this is different from license. So run with the land as explained above. Any subsequent owner or mortgage taking the property. So if you compare, if Mr. Jones were to rent a hotel for a month, this would normally be a license, since the hotel keeper has the right to come into the room, make the beds, clean the room, do any repairs, and even more, Jones to another location if it is deemed appropriate. But if Jones were to lease an apartment for a month, he would have the exclusive use of it, and the landlord cannot enter without permission unless some arrangement to do so had been set out in the lease agreement. So licensing has got more to do with hotels than has to do with homes. Then there's commercial tenancies. Properties can include unique terms and modified, normally included in rights and obligations, right? Excuse me. The landlord has no general obligation to deliver premises that are clean or in good repair. Property is taken the way it comes, unless if different was also stipulated in the agreement. So in Quebec, if you look at commercial tenancies, there are no formal requirements in respect of commercial leases. A lease between the parties will be valid provided it includes all the essential information as listed there. So if you look at the definition of a lease, the CCQ in effect since January 1994 defines lease as a contract. I will put a website for the CCQ so you'll have that after. As a contract by which the person, the landlord, undertakes to provide another person, the tenant, with the enjoyment of a movable property or real estate for a certain time in return for a rent. Remedies for breach. When the rent is not paid, the landowner can sue for the overdue rent. Certainly here in Quebec, you can't. You need to go to the board to apply for them to get the right to throw the person out or to get your money back. So when some other breach occurs, the landlord may sue for damages. So in serious cases, may require the tenants to vacate the premises. This has just happened in Quebec recently, where one tenant, for whatever reason, she decided to tear the apartment apart. Maybe I'll post that too, just to show you. Let me just note this down. Yes, so just to get back, I'm thinking as I go along. Yeah, there was one tenant just recently that absolutely destroyed an apartment, and she was considered to be mentally ill. And so now I'm not sure what happened on that case. I will look it up and I will post it to show you that sometimes landlords or landowners or apartment buildings owners, as much as they're not looked upon as being on the nice side when it comes compared to tenants, sometimes they do have a right, and they do have quite a few rights to throw somebody out, and I'll show you that. Forfeiture, the loss or giving up of something as a penalty for wrongdoing. So remedies for breach: when unpaid rent in a commercial lease is involved, no court order is needed, and the forfeiture may be accomplished by the landlord simply changing the locks. So you can't do this unless you have the right to do it from the board. There is also distress or distrain. Landlord of commercial premises has a right to seize the tenant's property and hold it until the rent is paid, or sell it to pay the rent owing. Residential tenancies, like consumer protection legislation, residential tenancy statutes alert the rights and obligations of the parties. So landowner is responsible for repairs, and tenants responsible to maintain minimal standards of cleanliness and pay for any damage they create. So like I said, I will show you something that just came up recently in Quebec, which was very startling. So period of tenancies, basically leases. Period of notice required when a landlord terminates a tenant or increases the rent has been extended in residential tenancies. Security deposit taken is strictly controlled. You'll see that does not apply here in Quebec. How often a rent increase can be imposed? Again, that is a big issue right across Canada. Different province, different rules. Landlord required to not eliminate any services in place. That's true. That works for here too. And the landlord has no right to of distress in a residential tenancy. Here's a website for, in case you don't know about this website, this is Régie du Logement Québec. Here you'll have all the information if you are a leasee or a leaser. So residential tenancies in Quebec, here's some rules. Landlord can't require you to pay additional fees or deposits. Landlord cannot ask for some private information. And here's one that a lot of people don't know about Quebec, is that it's illegal for a landlord to request post-dated checks. However, it's not illegal to ask for it. So you could ask for it, not demand it. And if the tenant decides to give 2 post-dated checks, that is their decision, not yours. So you could ask for them, but you cannot demand them. And there's so many rules and regulations like that here in Quebec, and I will probably give you a question like that in your questions when it comes later on, to compare provinces when it comes to this. So get ready for that. If you want to get ahead of, maybe you can take a look at that. So landlord cannot evict you at the time of your lease without just cause. Yes, they cannot evict. Even if your lease expires, believe it or not, they still cannot evict you. They need to go see Régie du Logement for you to have the right to throw them out. Great. So that's it. That's a lot of information in a very short period of time. That, mind you, that was 40 minutes. Great. So I'll stop here and we'll see you later.